All right, Josiah, it's on top of the hour. Let's go ahead and get started. And then if people roll in, they will roll in.
I'd like to welcome everybody to the Next Gen Mentoring Forum. The Next Gen Mentoring Forum series is designed to empower, educate, and illuminate individuals who are interested in the financial planning industry. At each forum, an expert will discuss a topic in the field of financial planning with the purpose of inspiring critical thought and discussion. In today's session, Dr. Jolly Jen will interview attorney Karakachian about the Secure Act. My name is Josiah Gonzalez. I'm a graduate program specialist in the School of Management. I am your host today, and I am also a proud CLU alumni of the MPPA program. Dr. Jolly Jen is an assistant professor and director of the financial planning program at California Lutheran University. She maintains an active financial planning practice specialized in succession program management at the Value Growth Institute. She's authored 3 books. Most recent peer-reviewed research book is by Palgrave Macmillan, Springer Nature, titled Enhancing Retirement Success Rates in the United States, Leveraging Reverse Mortgages, Delaying Social Security, and Exploring Continuous Work. Next Gen Mentoring Forum is sponsored by California Lutheran University School of Management Financial Planning Program. We offer MBAs in financial planning that helps financial advisors pursue a leadership position or grow their financial planning practice by deploying advanced financial planning, effective client communication / counseling, streamlined practice management, as well as leveraging fintech. I will turn over today's session to Dr. Jen.
All right, thank you, Josiah, and welcome everyone for today's session. I'm very, very honored to interview Haraj, one of our senior adjunct faculty here at California Lutheran University. Haraj started his career in the Big 4 accounting firms, eventually got so successful that he's now in a private practice, providing legal services in the tax, estate planning, real estate, and business advising services. And for those of you who have attended his class, you know that his wealth of knowledge in the tax area is incredible. So welcome everyone today for the session, and we are going to be trying to be as much interactive as possible. And first, I'm going to ask questions for Haraj that he oftentimes has this today in the history. So before you answer that questions, tell us, why do you typically have a today in history in your either LinkedIn profile or some sort of social media post?
Thank you for inviting me, Jolly, and welcome everyone. It's a great honor and privilege to speak with you and discuss this important topic. To answer the specific question, I love history, and I almost majored in history as an undergraduate, but
Wow.
There was a fight between accounting and history, and accounting won. And I've kept my interest in history by posting interesting tidbits, things that happen on a day, and I incorporate that in my presentations and on my LinkedIn profile. And today, it just so happens that it's Smokey Robinson's 80th birthday. He was born in Detroit, Michigan, and started his career at a very young age in 1955, when he was only 15 years old. And in the late 50s, he met and got to know Berry Gordy, and together they formed Motown Records. And as the saying goes, the rest is history. And he has no plans of retiring. In fact, when I read this tidbit, I went on Google and I saw that he's having several concerts in Las Vegas at the end of March.
Wow, that's incredible.
So what does this have to do with the Secure Act and retirement planning? Absolutely nothing, but I thought it would be a good segue. It would be a good segue into the Secure Act.
So Secure Act has a lot of, thank you for that. I thought that was very interesting to have a little bit of history, and interesting to learn that you almost majored in history, but still have that in your day-to-day passion and interest. Thank you for doing that. So Secure Act, can you kind of tell us a little bit about the history of how the Secure Act comes about and when it's come into the effect? So then we have a little bit background about what that is.
Sure. The Secure Act has been discussed in Congress for a little while now. It passed Congress in July of last year, but the Senate did not act on it until later in the year. The thrust and the focus of the Secure Act was to eliminate, the primary purpose was to eliminate the opportunity to stretch IRAs, and I'll get into it a little bit more. In addition to making some other modifications, Congress believed that IRAs were getting too big and individuals were being able to defer a tremendous amount of income through IRAs and by leaving it to the next generation. And as a result, the government was not getting its fair share of taxes. And one of the major provisions of the Secure Act was to eliminate the opportunity of beneficiaries to be able to delay the distributions from IRAs.
So,
it finally passed.
If I could just interrupt for a moment. Sure. So I tried to see the logic behind this, where the stretch IRA in the past. So I'm assuming the reason behind it is that the U.S. government wants to get the cash as soon as possible. Is that has something to do with that?
Exactly. Yeah. Getting the tax revenue sooner rather than later. Right. And just one point to note, an important point is, for the most part, this specific provision, will not have a major impact on IRAs in the $500 to $1 million range. Not that I'm saying that those are small IRAs. A lot of people would love having those types of funds in their IRA accounts. But it will have a major impact on the larger IRAs and larger retirement plans that have millions of dollars. And
interesting.
One of the triggers that was the genesis of this was an article that came out several years ago now, discussing Mitt Romney's IRA. And Mitt Romney's IRA had a fair market value at the time, I think this was in 2015 or 16, of over $100 million. And the discussion and the thought was, well, that's a tremendous amount of money, and it's not fair for individuals to have that type of deferred income in their IRA accounts. And hence we have to come up with some methodology to have taxes imposed on that accumulation of income.
Right. So in this case, Mitt Romney was started out several businesses and obviously have company stock inside that IRA account, hence that have grown to that tremendous amount of money. And so you're right. So the general public, which basically what you're saying is less than $1 million IRA account, probably is not going to be impacted the most, but they are particularly target those large amount of IRA. Can you talk a little bit about, in terms of, other than just taking the money out, and help us understand the required minimum distribution concept? Okay.
The required minimum distribution is almost all retirement plans, defined contribution plans. The owner of the account of that retirement plan is required to take out a distribution from the account after getting to a certain age. And if the owner of the account does not take out this distribution, there's some severe penalties, up to 50% of the amount that should have been taken out.
Right.
The age for this required minimum distribution under prior law was 70 and a half. Now, this is where the distribution becomes required. There's no provision in the law that prohibits anyone from not taking out a distribution from their IRA. Individuals who are younger than 70 and a half are able to take out distributions. There's some discouraging aspects to it. If an individual is less than 59 and a half, there's a 10% penalty. And that has been put in place to discourage taxpayers from taking distributions out of the retirement plans in the hopes of encouraging them to keep the funds and use it for retirement rather than for non-retirement purposes at a younger age.
And just to clarify that this applies to qualified account as well, not just the IRA account.
Correct.
Right, and then the
401k
current
plans, yes.
Right, so 401k for 3B plans, and the previous age was 70 and a half. Currently, the new law is 72 years old.
Correct.
And can you walk us through in terms of the actual timing of someone who must distribute, meaning that the age is set as 70, but when they actually has to take it out before that penalty of 50%, up to 50% kicks in?
Yeah, so the new law switched the required minimum distribution age from 70 and a half to 72. So the law requires an individual to take funds out after reaching 72, and the drop dead date for that first year distribution is April 1st of the year following the year in which the owner of the account turns 72 years of age.
Right, and the account balance is taken on when? Because it's not just the time, it's not just the April 1st following year, but the account balance is determined based upon what time?
So for the first year, let's take an example. If an individual turns 72 in 2020, they can take this required minimum distribution during 2020 on or before December 31, but they must take it before April 1st of 2021. Now that first year distribution, the balance in the account is the fair market value of the account, or accounts, if they have more than one account, is December 31 of 2019. And it is divided by their life expectancy as published by the IRS tables.
So oftentimes clients might be asking questions such as, if they have multiple accounts, as you alluded to, that you have multiple accounts, is it better to just consolidate everything into one account and do the calculation of RMD, or is it just take out from one account, satisfy those amounts? What's your preference, or what do you see in terms of what clients typically do?
There is a slight difference in the law where IRAs can be accumulated together and one distribution can be taken out from one account,
okay,
or multiple accounts. However, if an individual has a 401k and an IRA or IRAs, separate distributions have to come out for the IRAs, and another distribution has to come out for the 401k. So they cannot be consolidated. The 401k and the IRAs cannot be combined.
And so this is probably a reason that a lot of the custodians that holding these accounts have automatic setup in the account to actually force taking the money out of the account, because of the fact that sometimes you cannot consolidate all of these accounts together.
Yes, it makes it easier for the custodians and the financial institutions to have the automatic
Correct.
Distribution.
Correct.
To answer your specific question regarding the consolidating an IRA, it would make it easier from a financial management perspective to have one IRA account.
Sure. Yeah.
And rather than having 3 or 4 or 8, etc. So my suggestion and recommendation would be to consolidate the accounts, and that's fairly easy and straightforward to do.
Right, and I think that if you're working with a financial advisor or certified financial planners, they probably will be able to help you calculate how much you need to take it out in comparison to how much you need. And then so So those kind of calculations typically will be in place ahead of time before you run into problem like this. Now, one of the other aspects of the Secure Act was the contribution age limit into IRA. I know in the past, both IRA and Roth IRA have some sort of limitations. Can you talk about the limitations and then share with us what type of age limits today is in place based on the Secure Act?
So individuals were not allowed to contribute to traditional IRAs past the age of 70 and a half. That limitation has been lifted, but it only applies to traditional IRAs. There was no restriction for Roth IRAs. Individuals could contribute to Roth IRAs at any age. Also, SEP IRAs and 401k plans did not have that restriction either, so long as the individual was employed and was earning and had earned income from their work. The limitation, preventing individuals of contributing was specifically restricted to traditional IRAs, and now that restriction has been lifted. Of course, one important point is that an individual, an owner, to be able to contribute must have earned income or must have a spouse who has earned income to be able to contribute. If the individual just has portfolio income, that they will not be allowed to contribute.
So when you say earn income, does that also apply to Roth IRA if you continue to contribute into Roth IRA? I think a Roth IRA and IRA has earn income type of limitation. Is that still hold true for Roth IRA as well?
Yes, yes.
Okay.
And there's also income, adjusted gross income limitations for individuals to contribute directly to a Roth IRA. There is a backdoor IRA, Roth IRA opportunity as well for those who have higher levels of adjusted gross income.
And so this kind of get into a very interesting question where, all right, so we have the Secure Act actually push out the RMD age to 72. Meanwhile, you can continue to contribute into IRA, kind of conflicting, right? You have to take something out, but at the same time, you can continue to contribute to IRA. So from a practical standpoint, what would you recommend in terms of, from a client's perspective, why would they continue to contribute, and why would they at the same time being forced to take the distribution? What's your recommendation here? Yeah,
the conflict here is that if an individual must withdraw funds, if they're over 72 and a half, 72, they must withdraw funds out of the IRA and they are contributing into it, the additional contribution is factored into their ending balance at the end of the year. So their required distribution will end up being a little bit higher.
Right.
The recommendation and suggestion obviously is to analyze the individual's cash flow needs and how much funds they need, and make a determination based on the available resources and their available cash flow, and if it makes sense to make additional contributions.
Right. Now, the other questions that I have is that obviously, assuming that the target, this particular Secure Act is targeting a much more wealthy family, but for the mass affluent, would it still make sense if their tax bracket is low, just go ahead and convert them to Roth IRA? Would that still make practical sense if the tax bracket is low enough that, and if so, do they also have certain limit in terms of conversion?
Obviously, converting an IRA that has pre-tax contributions in it will have a tax impact, the
Correct.
Roth conversions. And I agree with you that if an individual is in retirement and they have a lower tax, they're in a lower tax bracket, to take advantage of those lower tax brackets. the stretch that I'd like to come back to in just a moment. There's one point that I want to clarify and expand on. The stretch has been that the Secure Act requires inherited IRAs and inherited retirement plans to be distributed out over a 10-year period. This was not the case with Roth IRAs, and now it is. So both accounts, pre-tax accounts and Roth accounts, have to, the beneficiaries have to empty out those accounts within this 10-year time frame. So the tax impact needs to be carefully analyzed, and some projections have to be made, including certain assumptions to make sure that and reporting of additional funds and income in years 1, 2, and 3 would be beneficial and helpful for the IRA account owners.
So in terms of this, the so-called stretched IRA in the past, now that individuals need to, the inheritance, if you will, has to take it out within that 10 years period of time. So the longest time is 10 years, but it doesn't limit people to take it sooner, obviously.
Correct.
And from a practical standpoint, the beneficiary, if you will, do they need to actually roll that into the inheritance IRA and able to take effect? Or how does it actually kicks in that 10 years so then advisors can advise their clients appropriately in terms of inheritance?
The Secure Act that got rid of the stretch did keep certain beneficiaries. The old rules do apply to certain types of beneficiaries. And those beneficiaries under the Act are called EDBs, eligible designated beneficiaries. And these EDBs are able to stretch the IRAs. And who are these beneficiaries? It's the surviving spouse of the account owner. It is a chronically ill beneficiary, a disabled beneficiary, a child, a minor child, not a grandchild, but it has to be a minor child of the account owner.
Right.
And beneficiaries that are 10 years within a 10-year time frame in age of the account owner. This group, these eligible designated beneficiaries, are able to stretch. So
if I were to walk through an example, so let's say if a husband and wife and survived by the spouse wife, that she was, let's say she's only 50 years old, then we can stretch based on her life expectancy at age 50. Versus if the beneficiary, if that goes to a daughter, then that won't be able to stretch unless she is a minor. Is that correct?
So the daughter will not be able to stretch, no.
Correct.
If she is the beneficiary of the IRA account, she has to take out the entire balance over a 10-year period.
10 years period of time.
Yeah. And it's at any point in time during the 10-year period.
So if I go back to Mitt Romney's example, he should probably marry someone very young if the strategy is not to take the money out as a surviving spouse, just to stretch, because it qualifies the stretching instead of just have to take it out within the 10 years period of time.
Right. If the beneficiary is a minor child, they will be able to stretch based on the owner's life expectancy, but only up until they become adult. They reach the age of majority, which in almost all states is 18, and then in a few states it's 21. And after they turn the age of majority, the 10-year rule applies.
So Terry has a questions in the chat box. She was saying that So by definition, if the beneficiaries is a minor, they can stretch based on the IRA owner's life expectancy until the minor reaches the legal age of 21.
Yes.
Okay.
And then after that, the 10-year rule applies.
Okay, good. All right. So in some cases, this is probably one of the biggest changes in terms of the stretch IRA. So at the end of the day, whoever is the surviving spouse, that spouse will die at some point. Therefore, that money is still going to be transferred to an heir that eventually have to be taken out by 10 years.
Yes.
So that kind of expedites the entire revenue collection process, if you will. Okay?
Exactly.
All right.
Exactly.
One of the things that you have mentioned in the Secure Act was the annuity options in 401k. Can you kind of walk us through what actually does that mean?
The Secure Act increased and expanded the disclosure requirements to beneficiaries or owners of 401ks who have included or purchased with the use of some of their contributions an annuity plan or a type of a vehicle that will provide them with income for life. And the Secure Act requires these plans, these retirement plans that have these options in them to provide illustrations to the beneficiaries of how the annuity plan will work and what type of income they can expect to receive. That's one modification. So it's more from a disclosure and information providing perspective to the account owner.
Okay, so
rather than increasing options.
Right. So maybe just let us back up a little bit so then people have a understanding of why this is a disclosure option. So there are pension, there are defined benefits and defined contribution plan. In a defined benefits situation, that distribution options are required by law. You have to provide, the sponsor has to provide all these different type of distribution options. Defined contribution in 401k's world, there is not really necessarily a policy requires for us. So this is a very, very first initiative. The government is trying to provide some guidelines. So in this case, it's a disclosure. It's not necessarily required for type of distribution option, if you will. So it's just from a plan sponsor or third-party administrator's perspective, they need to make sure that these information get disseminated to the employees as well as the plan sponsors. Is that the right assessment?
Yeah. If the 401k plan has an annuity type option in it where the owners have invested in them, they are entitled to additional information.
Correct.
Additional illustrations.
Right.
Also, the other provision too, which is important, these owners of these annuity type are allowed to, via trustee to trustee transfer, the investment from one 401k plan to another if there's mobility and movement of a job from one employer to the other.
Okay, so I guess the key things here is that many of the employer-sponsored plan do have annuity options. For example, like my husband works for a county or a state that they do have Prudential as part of their 401k plan, which in turns is an annuity inside. So in that case, he is expected to receive some sort of disclosure coming in terms of annuity options.
Yes.
So this is probably a good idea for the CFP or financial planner to know that when you're working with clients, although you can actually advise clients what to do with in terms of the options, but having this understanding will actually greatly help your service. Now, some 401k or even pension plan may or may not have that in-service withdrawal. And so those are the things that I think needs to be watching out for in case of making major mistake in the taxes and things like that.
I highly recommend financial advisors who do have clients that have invested in annuity options within 401k plans to ask their clients for these illustrations and review them with the clients and let the clients know the pros and cons and be able to advise them. I think there's going to be a better opportunity, more information, not necessarily better, but more information available to advise clients.
Right. And I think that these illustrations also could point out that did you save enough, how much you need to save, speed up the savings, as well as different type of distribution options available to them. So these are actually better opportunity for the planners going forward then.
I think so. More information. Yeah.
Right. So how about some small business incentives in terms of Secure Act?
There's several small business incentives. For small businesses that are 100 employees or less who do not have a formal retirement plan, the tax credit has been increased from, if they implement a new retirement plan, there's a $5,000 tax credit for the employer for a 3-year period. Also, the rules regarding small employers coming together and coordinating their retirement plans as a group has become relaxed. So that the goal and the hope for that is to increase opportunities for organizations to provide retirement plans to their employees, and also for smaller businesses who on their own would be expensive, cost prohibitive, and administratively burdensome to set up these plans can, and I don't know if this is set up as a marketplace, but some smaller employers could come together and form one retirement plan covering multiple employers.
And I think that these are great concepts in terms of helping businesses to provide opportunity for people to save. And so I can immediately think about industry associations. So let's say if you are in the construction industry, you have construction association. That association can probably help come up with a pool type of retirement plan, and their member can actually join. And so those are possible opportunities for advisor to actually work with the association or a group of similar type of businesses to provide those opportunities for family who have the opportunity to save for their retirement.
That's the goal. The goal is to make retirement more accessible and easier on as big of the working population as possible.
As possible, yeah.
Yeah.
And I think those are great step toward saving more for retirement. Although that I do believe personally, my opinion is that there shouldn't be any limit. If you want to save more, just go ahead and save more. I think that there are a lot more people need to save, but not taking the opportunity to do that. That's a switch gear a little bit about in the Secure Act. There's also non-retirement type of changes. Can you take us through the changes in the 529 as well as the kiddie tax?
Sure. On the 529 area, the two provisions that were put in place was the opportunity for beneficiaries of a 529 plan to use funds for apprenticeship programs, where before it was restricted to formal educational institutions, colleges, universities, but now apprenticeship programs are recognized, and that includes fees for tuition, books, supplies, equipment, for example, which would be helpful and necessary in an apprenticeship program.
Is that the reason to increase the skilled worker in the States? Because last year I had worked with a couple of large clients that their number one concern was that they cannot hire enough skilled workers. They have a team of people, HR team of people going down to the community for each one of the high school that they nearby, and they're just having hard time recruit skilled workers. So I'm thinking about maybe this is part of the reason to increase the amount of skilled workers in the U.S. by having this incentive in place.
That's definitely the main reason for it. The other reason is the 529 plans are usually set up early on. At least that's the goal and the hope of the 529 plans being set up early when the child is much younger.
Right.
With the hopes of the funds, small investments over 15, 17, 18 years would grow and be used to pay for tuition. But early on, when a child is born and this account is set up, the parents or the grandparents who form the account do not know what direction the child is going to take, whether they're going to go to a formal college or university and get a formal education, or they might go towards the arts and the other less non-formal types of programs in terms of graphic design, etc. I think that this option will allow individuals to some flexibility of using those funds, and as a result help create give the children more options, if you will,
right,
than just a formal education.
Right, and I think that you just spot on. You never really know that child or grandchild's which direction that person is going to go. My dad had always tell us that if your children turn out to be great, it's a gift. So you just never know which way they're going to go. How about the kiddie tax?
Well, one other point too on the 529, the new rules allow a one-time $10,000 distribution out of a 529 plan, not to pay for tuition and other fees, books, etc. For a college education, but to pay for a student loan, but only $10,000. So
that's on time. That's one time $10,000
one time per
specifically
account
for the student loan purposes.
Yes.
Okay.
Yes, but
that's good to know.
I think it's kind of counterintuitive, because when I read this, I was thinking the 529 is set up so that it's used to pay the tuition and fees and room and board and books, etc. Why would a student have a need to borrow funds? But maybe it's for a sibling. I guess there could be a circumstance or a situation where some funds could be used to pay down to pay down a student loan.
Yeah. Well, yeah, that does make sense. Some people who maybe went to school with scholarship, not knowing that they're still borrowing money, and so perhaps that this is one of the ways to kind of counterintuitively help the family a little bit.
Also for graduate school too.
Right.
Yeah. Maybe the scenario I'm thinking about is they finish undergraduate and go to graduate school for a couple of years, and there's not enough funds in the 529 plan, or they do not want to withdraw it at that point. They borrow, and then they decide to withdraw some funds at a later date. That's an option.
Right. So how about kiddie tax? Any changes in the kiddie tax?
Yeah, the kiddie tax, what happened was the rule was always that income of a child over and above a certain amount. And this is the unearned income of a child. The earned income of a child, dependent child, is taxed at the rate of the child. But this is the unearned income.
Okay.
And the rationale behind this, which was put in place in the 1986 Act, I believe, was to prevent parents from transferring assets to their children in the hopes of the children paying tax at a lower rate than the parents, because the children in theory, would have less income.
People are just so smart. We find ways to not pay taxes.
Opportunities for efficient taxation.
There you go.
The Tax Cuts and Jobs Act that passed in late December 2017 said, okay, we're going to simplify this and require the unearned income of children to be taxed at the trust tax rates. And trust tax rates are can be very high because the tax tables, you get to the highest tax rates very, very quickly at very low income threshold. And there was a whipsaw because certain children had unearned income as a result of especially for survivors of children whose parents had died in the military, and they were receiving death benefits from their parents, and some of that income may be taxable, and that income was being taxed at the tax rates, and the children were being burdened by the trust tax rates, which were substantially higher. And the Secure Act reverted the law to what it was before the Tax Cuts and Jobs Act. Now, the unearned income of children will be taxed at the parents' highest tax rate of the parent, which was the law in effect before the change. Okay. And there's an option to go back and amend returns for 2018 to take advantage of this. So this law applies on a retroactive basis to the beginning of 2018.
All right, good. Thank you, Haraj, for such an insightful conversations regarding about the changes in the Secure Act and how we can better serve our clients going forward. So I'm going to turn the floor back to Josiah. Josiah, you would need to unmute your line.
Oh, thank you, Dr. Chen. Thanks, Dr. Chen and Attorney Karakachian. We are so glad to have had you for the Next Gen Mentoring Forum. It was a very informative session. Thank you to California Lutheran University School of Management Financial Planning Program for sponsoring today's Next Gen Mentoring Forum. California Lutheran University School of Management offers MBAs in financial planning, helps financial advisors pursue a leadership position or grow their financial planning practice by deploying advanced financial planning, effective client communication / counseling, streamlined practice management, as well as leverage fintech. Please sign up for our info sessions for more information. Our next Gen Mentoring session is on Monday, March 23rd, 2020 at 2:30 p.m. Pacific Standard Time. Please join Dr. Jen to interview Jennifer Baccarella Wealth Consultants, LLC, about her journey of running a large broker-dealer, Sigma. Thank you all, and see you at the next Gen Mentoring Forum.